The Senate is back in order. I'm going to recognize the chairman of the special committee to investigate the election contest for Senate District 37 of the Mississippi Senate, Senator Burton. Mr. Chairman, you are recognized.
Mr. President, I move the rules be suspended for the immediate consideration of Senate Resolution number 7.
Motion is we do suspend the rules for the immediate consideration. All those in favor say aye.
Aye.
Any opposed say no. The ayes have it. The rules have been suspended. Now, Mr. Chairman, you're recognized.
Mr. President, would you ask the clerk to please read the title?
Mr. Clerk, please read the title.
Senate Resolution number 7, a resolution to adopt a remedy to the election contest for Mississippi Senate District 37 and Mississippi State Senate.
Now, Mr. President, make the usual motion.
Senator makes the usual motion. All those in favor say aye.
Aye.
Any opposed say no. The ayes have it. Senator Burton, you're recognized.
Thank you, Mr. President. Ladies and gentlemen of the Senate, this is Senate Resolution number 7, the report from the Special Committee to investigate election contest for Senate District 37.
Senator Burton, excuse me one second. I just want you to know that the 20-minute rule has been, you have 20 minutes, and at that point, 5-minute extensions will be granted by the body. So you're recognized.
Thank you, Mr. President. Always glad to abide by the rules. One of the things that I wanted to mention before we get into the resolution itself, there is a typographical error. I would ask for unanimous consent to fix that typo. There is a word that says conclusion that should be concluded. And I'm going to ask Senator Blackman, where was that exactly? You should point it out to 66. I see it concluded its hearing rather than concluding its hearing. I would move that we would ask unanimous consent to fix that typo.
Unanimous consent has been requested. Is there any objection? Seeing none, that word will be changed by unanimous consent. You're recognized, Senator Burton.
Thank you, Mr. President. Ladies and gentlemen of the Senate, first let me thank the staff, Bob Davidson, Chrissy Metcalf, and Bubba Neely, along with our court reporter Sharon Allen, Pat Trials, my assistant Mamie, who worked tirelessly during this process. They really, really went the extra mile and worked overtime, literally, to get this done. We heard over 15 hours of testimony, worked till 11:55 one evening. Some of us were here Saturday, trying to get this done and get it before the Senate. And I want to thank the staff for their hard work, and I just appreciate them more and more every day. We do more with less around here than any state I know, and we appreciate them very much. Not less in knowledge, but certainly less in numbers. I'd also like to thank the members of the committee, Senator Doty, Senator Frazier, Senator Fillingane, Senator Parks. They worked, never missed a word of testimony except one time when Senator Parks just had to slip out for just a minute. But other than that, everyone heard every word of testimony, took copious notes, made sure they paid attention, and listened to the case on both sides. The resolution itself has all those whereases in the front that talk about why the committee was set up, what happened to establish the committee, how the procedure is for the committee to be established. And we passed resolution number 2 on January 5th, list the members of the committee, and we concluded our public hearings on election contest. Went 3 days, 13th, 14th, 15th, and began its deliberations immediately thereafter on Friday afternoon. The parties were ably represented by counsel. I think those attorneys that were involved did a very good job of representing their clients' interests. And I can tell you this, the special committee, and I made the comment when we convened the committee the first day, we assume the responsibility as fact finders, and we assume that responsibility is very, very serious. Anytime, particularly this time, and Senator Frazier and I have been through this, down this road 3 times together in my 25 years here. We've done this 3 times. And anytime you have one of your colleagues involved, it's tough. It's tough. But this time, unlike the others, we had 2 of our colleagues involved. And it was doubly tough. We wanted to make sure we got it right. follow the law and the intent of the law and tried to maintain the integrity of an individual's vote. The council presented facts and legal arguments. We heard the testimony and conducted our deliberations, and we adopted the standard, as is usually the case, of preponderance of the evidence for weighing testimony. Under this standard, the petitioner, sojourner, had the burden of presenting evidence which is of greater weight or more convincing than the evidence which is offered by the respondent. The special committee heard 4 motions to quash subpoenas and subpoenas ducus tecum, which were ruled to be moot due to subsequent complaints. And after we ruled on those motions, numerous witnesses were subpoenaed. I think there were 10 from the petitioner and 5 from the respondent, witnesses that were called before the committee. We gave great latitude and leniency in allowing these witnesses to gather the facts and information that we need to make the right decision. Sometimes they rambled on, but we didn't interrupt them very often because we wanted to make sure that no one could say we were not willing to listen. There were 5 witnesses by the respondent Deering who testified with their legal counsel present. They had a personal counsel and professional counsel in their professional capacity or official capacity. These 5 invoked their Fifth Amendment rights on self-incrimination as they came to testify. As they did, I reminded them of Mississippi Code Section 5125, which provides immunity from state or federal prosecution or civil action to witnesses as to their testimony before a Senate or a House committee, and required the witnesses to present their testimony. So even though they invoked the Fifth, they were compelled to testify, and they did. We concluded the hearing into the contest. We think we were totally fair to each party, with the exception of obvious hearsay. All evidence was allowed. We didn't allow any hearsay. Other than that, we allowed the petitioner and the respondent to put on their case. They did, and we have come with a recommendation to you. We've concluded the hearing. We've delved into the facts of the contest, the Mississippi law that is involved in the contest, the findings of the committee, recommendations of the committee, Supreme Court rulings. All those things were considered by the committee. We have endeavored to render a fair and impartial recommendation, just like we said we would, and we recognize that these allegations are serious. We recognize that any time you're asked to overturn an election, that's a serious matter. It's also serious not to disenfranchise voters without sufficient cause. The Mississippi Supreme Court has ruled that the people who are electors should not be deprived of the benefit of their votes because those whose duty it was to hold the election were ignorant, incompetent, or willfully failed in some particulars to do their duty. Nor should the successful candidate lose his office because of the misconduct of these officials if he is free from complicity with them and does not gain the office by reason of such misbehavior. We heard from no witness, not one voter, who said that they were assisted in a way they did not want to be assisted. We didn't hear from one voter at all. Not one person came with an allegation of fraud or any malintent or illegality as far as them casting their vote, either in person or by absentee ballot. We did not hear from any person who said they believed that Bob M. Deering was complicit in forcing people to get people to vote for him. Not one single vote was challenged as far as they meant to vote for me, but they ended up voting for someone else because someone told them to. Not one instance. Unlike some of these cases that I've dealt with. The committee concluded in its report that the petitioner did not present a preponderance of evidence that the absentee voting practices in Adams County would have changed the outcome of the election of Senator-elect Deering, and that the petitioner did not present a preponderance of evidence that poll managers and election officials in Butte precinct in Franklin County provided unlawful assistance to voters which would have changed the outcome of the election of Senator-elect Bob Deering. Now, therefore, be it resolved by the Senate of the State of Mississippi that because it should not overturn the will of the electorate in the Senate District 37 general election, the Senate finds the Honorable Bob M. Deering is duly qualified and shall be permanently seated as a member of the Senate. We go on to say, as we usually do as boilerplate language, that he will receive the regular compensation and expenses of a member of the Senate and be entitled to all rights and privileges of the office, including but not limited to seniority retroactive to the beginning of the 2016 session. That's an explanation of the resolution. I move its adoption by use of the morning roll call, afternoon roll call. We'd be glad to answer any questions as I've made that motion.
Thank you, Senator Burton. Senator McDaniel, for what purpose do you seek recognition?
Question, Mr. President.
Mr. Chairman, do you yield for a question?
I do indeed. I yield.
You're recognized, Senator McDaniel.
Senator Burton, you and I have been here before, haven't we?
Yes, we have.
I just want to establish that right now for some of the new guys in here. This is part of the process, isn't it?
It is.
I remember a couple of years ago, I was up here, and I was fighting for eminent domain reform. Do you remember that?
Remember very well.
And you stood right over there, and you put about 30 minutes on top of me. Do you remember that? You
I don't know if it was 30, but
me.
it was a good long while.
It was a good long while. And we're still buddies after that, right?
Absolutely.
All right. So I've got some questions for you, and I want to be really clear that when I'm done with this, I still want to be your friend. Okay? You're not going to yell at me, are you?
Absolutely not. And
Okay.
for the record, I'll answer that in the affirmative. I'm fine with that. I'll be your friend.
Absolutely. But you're not going to yell at me, are you?
No, I'm not going to get.
All right.
Not unless you deserve it.
Okay, that's fair. That's fair. That's fair. I've deserved it a few times. A couple of things just so the new folks are clear as well. What you're bringing to the floor right now is not mandatory. The Senate can decide to do whatever they wish. Isn't that right?
Amendments could be offered, substitute motions could be offered. All is a process, but
Absolutely.
it's not mandatory that the Senate do what the committee recommends.
I just want to be clear about that because the first time I was here 8 years ago, I was under the assumption we were kind of stuck with a recommendation. But we're not stuck with a recommendation, are we?
No, you're not. This
Essentially,
is a
this
recommendation.
is Senator Sojourner's one last chance to appeal, isn't it?
This is where the vote is cast.
Absolutely.
To determine who will sit there. This is the recommendation, the unanimous recommendation of 5 members of the committee. That's what it is.
Yes, sir. It's a really unique process in that most of the time, if there are errors in the testimony or the fact finder misconstrues some testimony, normally a counselor has the right to appeal that to a higher court, right?
That's correct.
And this is our higher court today, correct?
This is the jury.
This is the jury. Yes, sir. I believe that. I believe that. The committee. 5 members on the committee, all fact finders. It's my understanding that you guys broke Friday to deliberate over the weekend. Is that right?
That's correct.
So a vote was not cast Friday, correct?
No, we did not vote until today in open session.
Okay. I received a text message Friday about an hour after I left this Capitol that the vote had been held. That's not true.
Not
then.
true.
And I'll be happy to show you that text message here in a few minutes if you desire. I can even put it on 8x10 over here, let the rest of the senators see it. But that did concern me. It concerned me for a couple of reasons. First of all, there were 2 days of testimony. And on the second day, I believe, and I was there for all of it, we stayed until almost midnight, right?
11:55 p.m.
That's a lot of witnesses. That's a lot of documents. Tell the jury how many exhibits were made a part of this case.
Oh, my goodness, I'll have to think out loud here, but there were about 30 or so on the one hand and 10 or so on the other, 50 or so, I'm guessing, around that.
Yes, sir. Considerable amount of evidence. In fact, we had a court reporter there as well, didn't we?
We did.
Court reporters paid good money to take down transcript testimony. Isn't that right?
That's correct.
I spent the first 2 years of my life out of law school as a federal United States law clerk. I didn't rule on anything until I saw the transcript. Did your committee see the transcript?
We have not, and in these instances in the past, the transcripts have never been made available until after the hearing and after the vote. It's part of the record because there is no appeal from here. It's not necessary to see the transcripts. What is necessary is that we know what was said. We took copious notes. Counsel took copious notes. We had our notes. Our own scribes were there doing it for us in addition to the court reporter.
Right, but you
And
know
we
this.
read the depositions beforehand.
Oh, absolutely. One of those depositions, Anita Leonard's, was about 250 pages, wasn't
It
it?
was a long deposition.
And you read every page.
I sure did.
And your committee read every page.
I can't speak to the committee.
Okay,
I know I did.
I'll get to that in a second. Transcript. The great thing about a transcript for a lawyer is that words really matter. Clever lawyer tricks really don't affect the words on the page, do they? Testimony is testimony, isn't it?
It is.
I called the court reporter today to ask her if anybody had requested the transcript for this record, and she said no, they had not.
Following procedure from the past. That is correct.
Why take a transcript if you're not going to read it?
So that it would be a part of the record for the Senate Journal.
A record for what? Just for the journal?
For the Journal.
Not for the appeal?
No, sir. There is no appeal.
This is my jury.
The
They don't
vote has-
have the benefit of a transcript.
A
Why?
committee report has been brought forward, Senator. There is no appeal from here. What we had down there was not
Yes, sir.
the final say. So the final say is here. This is the vote.
Yes, sir, I get that. That's what's odd about this, because normally a transcript is perfected for appeal. So it appears we had a court reporter down there who took a whole bunch of notes that nobody here is going to get to see, and I'm just curious, why did we waste state money on that court reporter if I can't see the transcript?
It's procedure.
Just
It's
procedure.
what we do to make
Just
sure the record is complete.
You know, something else that's interesting, fact finders, by their very nature, come into the courtroom with certain biases. It's just who we are as people. Some of us hate tort reform. Some of us like tort reform. Some of us love Republicans. Some of us hate Republicans. Isn't that right?
Oh, that's true of everyone in the world.
It really is. Biases are really important for the fact finder, because if a fact finder is biased, it can cause them to misinterpret testimony. Isn't that right?
It depends on how you look at that, Senator. Fact of the matter is, if we are there to determine the facts, we are open-minded. And I know that the colleagues that I had on that panel were open-minded. None of them had any preconceived notions of what they believed would happen or who they believed should be there until they heard the testimony. We talked about that. I felt that same way. So for you to sit there in judgment of us and tell us that we knew what we were going to do when we got there is just downright wrong.
I'm just asking questions. I'm not judging.
You said it in an accusatory way, sir, and I refuse to stand here and let you drag me down into your pit of iniquity. It's not going to happen with me.
You told me you were going to yell at me.
I'm not yelling. It's coming, though.
All right. Let's talk about that for a few minutes. Let's talk about that for a minute. You know, look, credibility matters, and I get that. And I like you a lot, and I've enjoyed serving with you, no question about that. But bias is a reality. You know, it's funny, in a jury trial, I get to talk to those fact finders before. I get to ask them questions about their preconceived notions of facts, of law, of ideas. I didn't get that opportunity this time, did I?
No, sir, but the lieutenant governor did, and that was one of the things that I was asked. Do you have any preconceived notions about what should happen? And my answer was no, sir. Didn't the first two times I did this, and I don't this time.
Well, the attorney for Senator Sojourner did not get that opportunity because that is part of procedure. I get that. But that still leaves open the possibility there could be some remote bias or some remote misinterpretation. And that's why I love the idea of having a transcript, but I still haven't seen, because those words are not subject to bias.
And
But
you
I-
won't see it this afternoon either.
Yes, sir, I
It's
know.
just the process.
I know. And that makes me wonder why it is we're holding this meeting today, and the jury is not able to see all the evidence. I guess that's just procedure. And with all due respect, and there's nothing wrong with this, we're a body of politicians. You may have heard, back in 2014, I ran against Thad Cochran.
I heard that.
You heard that? Yeah, they did too. That run was probably one of the most nasty primaries this state has ever seen, right? You saw it.
It was pretty ugly.
Created division in our party, didn't it?
Well, I can't speak to that. They made some irritable with either side, one side or the other, yes.
Yes, sir. Well, I think it created division with another party, and that's unfortunate. But the reality of the matter, people in this room and people in leadership and people all over the state had to choose sides between the old guard and something new, correct?
Well, I saw it as choosing between candidates, not sides of the old guard or the new guard. It was choosing
I get
between
it.
candidates for me.
I get it, absolutely. And it's clear to everyone in this room that Senator Sojourner was my campaign manager, right?
Yes, I heard that.
Right. Are you aware that at least 2 members of your committee were active in attempting to unseat Senator Sojourner in her Republican primary?
I did not know that.
Be nice to have that transcript. A couple of more things. We're sitting here in this body. Oh, and by the way, I do have the screenshots of their social media, and I'll show you that later. We're sitting here in this body today, and as a general rule, our committees are designed to make law, right?
To recommend law to the body, yes.
But in this particular instance, this is different. That committee is bound by the Mississippi Supreme Court, isn't it?
But this isn't a law. This is a work product as a result of a law.
Yes, sir, I get that. I get that. I'm just saying, from the standpoint of precedent, from the standpoint of guiding, our foundation here is not law that we have created. I mean, you wouldn't have gone down here and misconstrued or recreated some law. You were bound by the Mississippi Supreme Court, were you not?
That's correct. The Supreme Court rulings and so forth, as we interpret them to be relevant to this case.
Yes, sir. Those cases are precedent, and your first job was to follow that precedent. Secondly, there were statutes that you had to interpret.
20 minutes is up. 5 minutes has been requested. All those in favor say aye. Any opposed say no. The ayes have it. 5 minutes extension will be granted. Senator McDaniel, you are recognized. Senator Burton, do you yield for questions?
I do. I hesitantly agree to the extension.
Yes, sir. Yes,
You're recognized, Senator McDaniel, for further questions.
Yes, sir. The statutes on the books are statutes we're obliged to follow. Isn't that right?
Yes.
You're not contending that the statutes on the books presently have been repealed, are you?
No, not, well, they might have been repealed in the past and reestablished, but as of now, they are the law.
Yes, sir. And I want to get to some of those statutes in a second. But first of all, I want this jury to understand the division here. Only 64 votes divided these two candidates, correct?
Correct.
64 votes. So if Senator Sojourner's lawyer at trial was able to cast doubt on 64 votes, the Supreme Court of our state has said that uncertainty mandates a new trial. Isn't that right? Or a new election.
Correct.
That's right. 64 votes is all they had to put into play. And it says the uncertainty of the voters at that point would not be able to be ascertained. That's correct, isn't it?
That's correct.
And any time that there is a statutory violation, the court calls it a mandatory violation. Any violation, that means that that particular vote is illegal. Isn't that right?
That's not what it means.
That is
That's not what the court has held.
Well, let me read it to you. Let's get it straight. Upon violation of a mandatory statutory requirement, the vote is deemed illegal. That's Thompson
You're
versus
quoting
Jones.
from what case?
Thompson versus Jones, 2008.
I've heard that one.
That's 3 years past the Boyd case you relied on so
I
heavily, isn't
understand
it?
that. I understand what you're saying, but we also, a lot of that has to do with the fact that another, and you'll get to this, but the code section under which one of the poll watchers brought in the questionable activity at the Butte precinct doesn't even apply to precincts with those types of voting machines. It applies to those types of voting apparatus. It applies to voting machines, and I don't know that there's a voting machine left in the state.
Are you talking about the improper assistance statutes?
Yes.
That idea was first promulgated in 1872. It's been a constant in our law for 105 years. In O'Neill versus Simpson in 1977, it spelled out precisely that that law is good law, solid law, and you cannot provide assistance to a voter unless they declare their need under 3 very specific circumstances. Correct?
In 1977, that was correct. With the technology today, the touchscreens didn't even exist. The DRE machines didn't even exist. As a matter of fact, in 1986, the legislature, in its wisdom, repealed that statute. It suddenly reappeared in 1987, but it was repealed in 1986.
I am glad you brought that up. That's an outstanding point. And I want to get to that. Here's the thing. O'Neill, the case you say has been basically repealed, was cited by Strawder in 2002, analyzed by Strawder in 2002, and found to be good law. It was cited again in 2005 and found to be good law. O'Neill was then cited by the Encyclopedia of Mississippi Law. Jeffrey Jackson wrote that. It is the preeminent secondary source for lawyers in this state. That was cited in 2015. It's been shepherdized. It's been cited 22 times in the last year in sources all across the country. Our United States Attorney General cited it in 2008. It's good law, and it has been good law. But you're saying that it's not, and now I'm beginning to understand the decision you reached.
No, you don't, obviously, sir. One of the reasons we reached the decision is regardless of what the statute says, no single instance from one single voter was presented that said, my vote didn't count, my vote was tainted, my vote did this, my vote did that, my vote disappeared, my vote went to the wrong person. Not one.
It's not the standard. The statute speaks to a person having to declare assistance. If the poll workers or anyone else attempts to help that person, if they haven't declared for assistance, it's a violation of the law. And you said earlier there wasn't a single witness up there that testified to this
I did not
effect.
say that.
Jake
I said
Hawley,
there was not a voter who said their vote didn't count.
Jake Hawley, lifelong Franklin resident, worked as a poll worker since he was 18 years old. He walks into the poll that day. He literally watches a poll worker. He watches her cast the vote for a voter. That's illegal, isn't it?
There was no testimony that said I was voted wrong. I didn't intend to vote that way. The vote shouldn't have counted because I voted the other way. Not one.
You would understand that
The
state law,
burden was on proving that, and it wasn't proven.
it was proved. State law does not.
The 5-minute extension is up. 5 more minutes has been requested. All those in favor say aye. Aye. All those opposed say no. No. The ayes have it. 5 minutes will be granted.
Now,
Senator Burton, do you yield for a question?
I do.
Senator
thank you.
McDaniel, you're recognized.
Thank you, sir. Senator Burton, I mentioned a moment ago that O'Neill had been cited as good law literally dozens of times just in the last couple of years. The dissent of O'Neill is particularly illustrating in this case, isn't it? In that dissent, they broke down all of the evidence that was elicited during that trial. And I thought it was interesting that the attack that a dissenting judge had against the witness was that the witness estimated a number of votes that were improperly assisted. Estimated. The witness guessed. And that was still good enough for the O'Neill court to throw out 70 votes. Isn't that right?
And you're the lawyer, not me. Don't claim to be one. But isn't that the case where one of the concerns was that the person who was charged with illegal assistance was a worker for the candidate who won? Is that not the case?
The law makes no distinction in that manner. In fact, it would be worse if it were an actual trained...
Well, it's in one of those cases that
Yes, sir.
that the petitioner cited.
It would actually be worse if it was an actual poll worker under the color of state law, which is what happened here. In O'Neill, it was just a watcher, not a worker. So this case is much worse than O'Neill. And another
One
thing...
indication was not one. I say indication. Lots of indications. Lots of innuendo. Lots of I believe this. I believe that. But not one instance from that witness you're talking about, with all those cases that they talked about, was shown to change one single or mark one single vote void and illegal. They saw shoulders moving, they saw hands moving, but they could not say they saw it on the screen. They heard stuff, but they didn't know what they heard because it was too noisy. Someone could have asked for assistance. We're just saying that in those instances, the mandatory application of the law is very important. But the most important thing is the sanctity of the individual vote, and not to deprive those people who voted in good faith through no fault of their own, who did nothing illegal, who did no fraud, who perpetrated no fraud, that their vote should count. And that's what we said, the vote should count, and that's how the committee decided to vote.
Everything you just said is contradicted by O'Neill, by Harpole, by Thompson, and that's just the tip of the iceberg. Mr. Chairman, just let me read, since we don't have a transcript, Mr. Hawley's testimony, and then I want to get to the real evidence. This is what Mr. Hawley said there at the day. He says, "While I was at my voting machine, I watched the poll worker come into the machine beside me and vote the ballot for the voter. She then stepped aside, let the next voter up to the machine, and voted for the ballot for that voter." Here's the cross-examination. "Isn't it possible that she was just giving instructions to the voter?" Answer: "No, sir. She voted the ballot. I watched her, and I was appalled. I have no confidence in the integrity of my vote because of these actions." He wasn't the only one. A Republican poll watcher was there, sent by the president of the Franklin County Republican Party. He sent his wife there to watch for irregularities because there had been so many reports of bad behavior in Butte. Isn't that what the testimony said?
That's correct.
So many reports of past bad conduct in Butte that the president of the party sends his wife down there, another trained poll worker, trained by the Secretary of State. She's there looking specifically for illegal conduct. Isn't that right?
That's correct.
She took a notebook. Did you have a chance to read her notebook?
I did not read the notebook, although I did read the deposition.
Okay. You need to read the notebook. It's better than a transcript, and I'll tell you why. She was there from 7 in the morning to 3:23 in the afternoon. Isn't that right?
That's correct.
And in that brief period of time, she made 228 detailed notations. Isn't that right?
That's correct.
26 pages of detailed notations. Isn't that correct?
That's correct, including
And if-
things like she's wearing a wig.
Well, no. I'm going to get to that. And of those 228 notations, she noted 129 direct violations of statute.
What she believed to be direct violation.
Eyewitness testimony by a trained poll worker sent there to watch for illegal activity. If we're not going to believe our poll workers, who are we going to believe?
Not poll worker, poll watcher.
Even better. Aren't they there to make sure there's integrity in the election?
They are if they know what they see. She testified on cross that she couldn't tell what the person was doing, but she assumed they must be voting because the shoulders were
5-minute
moving.
extension is up. 5 more minutes has been requested. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it, Senator, but I'm going to let you continue your questioning, but let's conclude it at some point.
Here's the thing, and I'll get to the chase in regards to this particular document. We don't have a transcript, but we
Correct.
have exhibits. This exhibit is detailed. It breaks down 129 separate instances of violations by a trained Republican poll watcher whose
What she
husband
believed-
is the
yeah, what she
president
believed
of
to
the
be
party.
violations. That's
Yes, sir. Let me ask you this serious question. And I don't mean any disrespect to her or you when I say that. Do you believe she was lying to that committee?
I don't believe she was lying. I think that she believed she saw a violation, but she couldn't prove she saw a violation by her own words.
All right, since the Senate is pushing me to wrap up my questions, let's go right to the heart of some more evidence, okay? So right now, sitting here today, I've documented at least 131 violations. Haven't even gotten to the absentee ballots yet, or the failure to secure the ballots in Adams County. Let's talk about the workers that were that day in view, the actual people that were there on behalf of, I guess, the state, the election commissioner, and 4 trained poll workers. Remember those women testifying?
I do.
All right, now this is where this case gets really interesting because each of those women conceded that they had violated the law. They admitted on the stand, didn't they, that they had violated the law.
They conceded that in small communities, when you work the polls, as long as they have, you know the people who need assistance. So why allow them to embarrass themselves when there's no reason to? And they cited, I don't know, 10, one of them cited 10 that they helped that day, another one cited some more, and so forth and so on. But the fact of the matter is, Senator McDaniel, I know you're a literal person. You're a lawyer. You're an academic. You're a lawyer. You're smart. You're a literal person. But I believe at some point there has to be some common sense to come into play when it comes to the mandatory application of the law. One of those would be if Ms. Jones has voted for 40 years and Ms. Jones has been blind for 40 years, chances are a miracle hadn't happened since the last election, and she needs some assistance in voting. Why should she have to declare on Election Day that she's blind?
I'll tell you.
That's what I'm
Yes, sir.
talking about. That's what these folks were talking about.
Yes,
a
sir.
little bit of common sense.
And I can answer that question. Why does she have to declare? Because I've got 3 cases and 3 statutes that say that law has to be strictly enforced. Those aren't my words. Strict enforcement is a legal term of art. There's no wiggle room. There's no speculation. You cannot provide assistance. You cannot approach that voter unless they declare that they need assistance based on 3 very restricted concepts or exceptions in the rule. I didn't make this rule up. It's law. That's why I'm being strict, because the court is calling for me to be strict. It's saying strict enforcement. Each one of those ladies, didn't they, Senator Burton? Each one that testified said to that room that they violated the law. Didn't they say that?
They didn't say they violated the law. They said they offered assistance.
They offered assistance without the party declaring and without one of the 3 primary reasons being declared or explained. Now, I want to go, I don't have a transcript, but I took good notes too. And I just
I'm
want
sure
you,
you
I
did.
want to read some of the election commissioner, what she said. Now, the election commissioner is in charge of training all the others, right?
Correct.
Right. She said that most of the help they give comes to those who just don't feel comfortable. That is a violation of the law, is it not, Senator Burton?
In mandatory, literal terms, yes.
Strict enforcement. That's exactly what the statute calls for, exactly what the Supreme Court says it's called for.
But the voter themselves broke no law.
That's beside the point. The courts have ruled on multiple occasions. It doesn't matter if the voter breaks the law. And I'll go over those cases if I'm allowed to speak in a second. Here's the other poll worker there, Gloria Smith Taylor. She testified when someone comes in for help and doesn't know how to work the machine or to cast a vote, we help them.
Correct.
Senator Burton, that is a violation of Mississippi law, is it not?
But the court is, in instances, it has decided not to invalidate votes because of those types of violations.
They invalidated in Strawner and they invalidated in O'Neill. 70 votes in O'Neill were thrown out. We're not looking for 70 here. We're looking for 64.
We're looking at anecdotal evidence here in most of these cases, because those, going back to that other witness you were talking about, that's anecdotal evidence. There was no evidence from that poll watcher.
Sir.
These individuals testified maybe 10 times. 10 votes does not meet the standard of 64.
Sir, there is nothing anecdotal about eyewitness testimony. Eyewitness testimony is based in fact as it was perceived. That's not anecdotal. That is absolute truth.
She
And
never said she saw a finger touch the screen.
yes, she did. And she also said,
5 minutes extension
One.
has completed. 5-minute extension has been requested. All those in favor say aye. Aye. All those opposed say no. No. The ayes have it. Senator, let's conclude.
yes, sir. All right, so that's the third. The first person that claimed or admitted they violated the law was the election commissioner. There have been 2 more poll workers also admit they violated the law. Admissions aren't anecdotal. Admissions
correct.
are admissions.
Understand that.
Okay, what about Ann Reed? She was another poll worker there.
That's correct.
Okay, her testimony was people get help whenever they want it. Isn't that what she said?
So what now? Say it
She
again.
said they get help whenever they want it.
That's correct.
All right, Ann Reed said that. That's a violation of the law by admission. And this is the best part of her testimony. I don't have a transcript, but I took really good notes. She says she would whisper to them. Question, why whisper? I wouldn't want anyone to know what I was saying to the voter. That's a violation of law. Isn't it, Senator Burton?
I don't know that.
Statute says that it is. Donna Jones, the 4th poll worker, she said as well, we do it all the time. And she admitted that she had never even read the statute prior to that evening, didn't she?
She did.
She had never read it, didn't know the law. In fact, not one worker in that precinct knew the improper voter assistance law, did they?
Your opinion.
Not one. Not a single person there knew the law. But
Your
they're
opinion.
supposed to make sure that the votes are handled with integrity. Oh, and by the way, the 129 notations that are specific in that notebook were as of 3:23 in the afternoon, correct?
That's correct.
And the bigger part of the traffic comes in past 7, correct?
I'm not sure what time they voted and viewed.
The taint of illegal activity, the taint of intentional activity is more than sufficient, particularly with this type of evidence, to more than overwhelm that mere 64 vote margin, isn't it?
The committee decided that based on the standard of preponderance of the evidence, that poll managers or other persons assisted voters who were not qualified to receive assistance, but they indicated belief that the interaction by poll manager and voter requires the voter to first declare he needs assistance to vote by reason of blindness, disability, or inability to read or write, and this declaration must be heard or verified by persons other than the poll manager. That's not what the section says. That's not what it says. She says she saw poll workers' shoulders moving. She saw hands moving. She saw arms moving. And they were talking to each other various times. She couldn't hear what they were saying. She has no idea if they asked for assistance or not. First, precinct was noisy with numerous people speaking at the same time. Second, she was
Yes, sir.
seated 18 feet away.
Yes, sir. As to the issue of noise, every one of those women that were working there that day, every one testified that it was, quote, very quiet, didn't they?
I don't know about everyone, but some of them did, I know for sure.
Very
I read
quiet.
the transcript.
You know, it's funny. Last year we passed a texting bill, and we expected the police to read people's minds all the time as they look down. But you're telling me a trained poll worker can't discern from 18 feet away, basically from here, whether or not I'm touching this, even though she can't see my
She's
hand.
facing the back of the machines.
You can't see
She
movement
was
that
facing the
indicates
back of the
movement.
machines.
Then I guess
If she can see the vote being cast from 18 feet away, looking through a metal machine back,
yes, sir.
then
I get that.
that's not any of those votes.
No, well,
It's not a private vote.
but she didn't have to see because they've all admitted they were doing it.
Not when she testified.
Ann Reed testified she touched it. Ann Reed testified she pushed it with her finger, didn't she? She was a poll worker there that day.
I don't remember that, but maybe
Jake,
so.
Jake was in there that day, and he witnessed her do it. He says she did it.
Now, I thought Jake said that he saw it on primary election day. Not,
He was there on the general election day, yes, sir.
Because he just said he had to vote and go back to work.
To respect the body, I realize I'm going to have a chance to speak on this, and I'll do that. Just two more questions. As to the issue of Waters, which is good law, passed in 2005 or rendered in 2005, right?
Right.
Waters deals with ballot security, correct?
Correct.
Yeah, that's an important deal in this state, isn't it?
It is.
If you don't protect the sanctity of those boxes, there's no way to know whether or not the election was held with integrity. Isn't that
That's
right?
correct.
Do you know this case is almost on all fours with Waters? It is eerily similar. Did you read Waters?
I did not read the entire.
The facts are almost precise. Why is it in Waters they ordered a new election with these exact facts, and this body does not want a new election?
Well, different voting machines for one thing, different types of voting machines, and the ballots are kept in a secure location in cardboard boxes, and the courts, in some opinions, have said that's okay as long as they're secure. They frown on the envelopes, and they frown on other options other than the ballot boxes, but they don't totally say so.
I speak the
5 minutes has concluded. Any further questions of the chairman?
I gladly yield the podium.
At this point, I'm going to let Senator McDaniel want to speak. Senator McDaniel has an amendment. The clerk is going to put the amendment on the screen. Senator McDaniel, on amendments, you have 5 minutes with 5-minute extensions.
Thank you, Mr. President.
You're recognized to explain your amendment.
Thank you. At the end of the day, and I can speak to the larger bill here in a moment, but there are a couple of things that are very obvious here. It is beyond question, indisputable, that violations of the election code, particularly those of this magnitude, always render a new election possible. But not just possible, it's almost mandated. The court said several times, if you break outside this radical departure concept of voting, these mandates, then there's a real problem. You got to make sure the will of the people is upheld. You do that through a new election. 64 votes. Nothing. Direct allegations here of 129 detailed actions that violate state law. That's without taking into consideration that each of the poll workers there admitted to violating state law. The election commissioner admitted to violating state law. The witness, Jake Hawley, he was there in the room. He saw the violation of state law. This isn't even close. That creates the uncertainty. And it's a magnitude times 2. And that's just the tip of the iceberg. Let me tell you something. Guys, I know you're probably tired of hearing this, and I apologize. I want you to indulge me because I want to understand how it is this body cannot render a new election. Listen to this testimony. Now, we don't have a transcript, but we've got testimony here. Do you know the sealed precinct boxes were brought back to the Adams County Courthouse that night? During the absentee count, they were opened, unsealed. Everything was taken out. At that point, all of the information in those boxes, that's applications, envelopes, books, everything, for both accepted and rejected ballots, were thrown into a cardboard box. Since that day, they've been kept in cardboard boxes. The box with the ballots were in an open top box. The absentee applications and envelopes were in a separate cardboard box with no seal. Why does that matter? There's a case right on point. It's the Waters case. It's 2005. You have to have a seal. You have to secure the ballots. You have to make sure everything is done appropriately. This was perfectly as aligned in Waters. Waters ordered a new election. Listen to these words. 23-15-591. These materials have to be enclosed in the ballot box. They have to lock the ballot box. That didn't happen. 23-15-911. It's so bad. Guys, do you know if you challenge an election, and I've done it, they don't even want you near the Holy of Holies. You have to jump through a number of hoops just to gain access to this ballot box that's so important. It's supposed to be sealed with a steel tie, according to statute, where the materials are undisturbed until the people who are part of the challenge get to look at them. They were in a cardboard box. And you say, what's the problem? Well, one of those boxes was in an office. You know what the testimony was? There were at least 6 keys available to that office. Even the janitors had keys. The other was in a broom closet.
Senator McDaniel, you have a minute left. I'm going to suggest you explain the amendment, what it does.
The amendment is this, Mr. President. I apologize. Every case I've read, all the facts point to one conclusion. There needs to be a new election. This isn't about Sojourner or Deering or anyone else. It's about such incredible wrongdoing that you can't have faith in the certainty of the race. And that's the test the law uses. And I realize I'm a minority in this room. I get that. But following the law shouldn't be a minority position. If we are not going to follow the law as the state Senate, then who is? Strict enforcement is strict enforcement. That's what the case law says. The laws are clear. And get this, 18 separate violations of your statutory code in one county, Adams, and one precinct in Franklin, Butte. 18 different violations. Are we to turn a blind eye to that? All I'm asking for is that we do this again to make sure with new poll workers that the result is the right result.
5 minutes is up. Thank you. The opponents If anyone would like to speak against, would have 5 minutes also. Senator Burton, you are recognized.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I'm asking you to vote against the amendment. The courts have ruled in several instances on the use of cardboard boxes that he mentions in Adams County. As a matter of fact, the court frowns upon the substitution of manila envelopes for ballots and cardboard boxes and so forth in that Riley case. But in another case, the key is deciding whether or not the use of cardboard boxes was a suitable substitute for the ballot boxes. The court in Barnes versus Ladner ruled that that is not a total departure from the fundamental provisions of the statute, such as to destroy the integrity of the election. So, Mr. Gardner, the elections commissioner down there, who helped write the statute that was adopted in 2006, has been keeping these ballots in a secure location in cardboard boxes sealed with packing tape for years. And that's what he did this time, as in other times. It was never testified to that those boxes were not in a secure location. The only question was, why weren't they in the ballot box? That's been the way it is since they adopted the DRE machine use down in Adams County, and that's the way they did it this time. I urge you to vote against the amendment.
Would anyone else like to speak against the amendment? Seeing none, I will recognize Senator McDaniel to close on his amendment, and 5 minutes will be granted.
Mr. President, thank you. I'm not using my words. He cited a case from 70 years ago. I'm going to cite one from 2005. In accordance with the section 2315-911-1, the ballot boxes should have been pristinely maintained and monitored by the circuit clerk, who had a duty to safely keep and secure the ballot boxes against any tampering both before and after a box examination. However, as evidenced by the record, Section 2315-911 was unquestionably violated when this guy cleaned out the boxes, placed the contents into 2 cardboard boxes, and sealed them with a single piece of tape. One of our boxes didn't even have tape. These are the court's words now. These aren't mine. We wish to make abundantly clear that our decision today should in no way be perceived as even inferring intended wrongdoing by the Holmes County election officials. That goes to the next point. He's arguing you got to show wrongdoing. The court's saying, no, you don't. If the departure from the statutory code is bad enough, you don't have to show wrongdoing. Listen to these words. This is the court, not me. Just a few years ago, there is nothing in the record to suggest that one or more of the Holmes County election officials acted or failed to act with sinister motives. They said it's always the way it's been done. It's exactly what Senator Burton said they said in Adams County. This is always the way we've done it. This is all. You know what the court said? Tough. I'm going to read it to you. We understand this mindset. It's quite common that when newly elected officials take office, they rely on the advice of their predecessors and other informed officials in learning how to perform their respective duties. If a newly elected official is told that this is the way we've always done it, and it seems to be fair, and it's been successful, then why rock the boat? But listen to this. While we rely on our elected officials to educate themselves on the appropriate laws governing their duties and responsibilities, we acknowledge the fact that our elected officials quite appropriately rely on information gained at seminars. And then it continues. At the end of the day, in the conduct of these races, voters have to rely on experience, expertise, and integrity of our election officials to perform their statutorily mandated duties and to assure that elections are fairly and properly conducted. Having found, for the reasons above, cardboard boxes, we find the special election is in order. The real test is whether the boxes were pristinely maintained. The evidence is overwhelming that they were not. And that's just in Adams County. You would have to ignore every other part of the case, including the Adams violations, not to grant a new election.
Senator Burton, for what purpose do you seek recognition?
For a quick question, Mr. President.
Does the senator yield for a question?
Yes, sir.
You're recognized, Senator Barton.
Thank you, Senator McDaniel. Thank you. Senator, in the Nemi case, is it not true that those ballot boxes were kept in the basement in a totally unsecure location, no lock, no nothing, that those cardboard boxes were ruled by the courts to be in an unsecure cardboard box in the basement of the building, and that's why the integrity could not be ascertained. In Adams
not the
County,
case.
things are totally different, aren't they?
That is not the case.
That
Absolutely
they were
not.
in
Absolutely
the
not.
election commissioner's office under lock and key.
The court did everything it could to overrule the old case in 2005, then came forward with a new case and a new standard. And it said perfectly clear that you can't allow this type of conduct. This box was occasionally under lock and key. It's not the idea that you're occasionally under lock and key. It's the idea that they violated the statutes.
Sealed with packaging tape, under lock and key, in the election
No, sir.
commissioner chairman's office.
No, sir.
Down there in Adams County
No,
is what
sir.
he testified
No,
to.
sir, he did not. One of the
And-
boxes. No, sir. One of the boxes was in his office. The other was in a closet.
The other question I have for you is, did the court overrule Riley?
Oh, yeah. Oh, but yes. This is the new case, 2005. This is the most
They
pertinent,
did not
relevant case.
overturn Riley.
Here's a better-
They referenced
Yes.
it, but they did not overturn it.
It was a security question. This resolved the security question once and for all. For someone who claimed that O'Neill was overruled, that's a stretch. That's a real stretch. Our law is very clear. Let me just finish with this, Mr. Chairman, and I'll sit down. Integrity of our government can be no greater than the integrity of elections, which put our government officials in office. It is therefore the duty of every registrar to endeavor to comply with the election statutes, regardless of the personal inconvenience
5 minutes is up.
it may cause. That's the law. And it's
5
brand
minutes
new.
is up. Thank you, Senator. The question now will recur on the amendment. All those in favor of the amendment, I'm going to ask to say aye. All those opposed, I'm going to ask to say no. All those in favor say aye. All those opposed say no. The noes have it. Amendment number 1 fails. We are now on final passage. Senator, you're recognized for a motion.
Mr. President, I move adoption of Senate Resolution Number 7 by use of the afternoon roll call.
Use of afternoon roll call has been suggested. I believe Senator McDaniel would like to speak on final passage. We do have 20 minutes, Senator McDaniel, plus any extensions.
Yeah, I won't
You're
take-
recognized.
Like I said, I realize this is a minority position. I'm accustomed to that. But I know this is right. I know it's right. It's the law, and it's clear as a bell. And this body is turning a blind eye to it. When I was a kid, my father used to drive down the interstate here. And just outside of the view of the buildings in Jackson, we could see the dome. And he would point to it and say, "That's a pretty special place." And it is. It's beautiful. It has all the marble in the world, it seems. Beautiful carpet, tapestries. But it's just a building, man. It's just a building. The courthouse is no different. No matter the magnitude of the building or the beauty of the building, it's what's inside that counts. You are about to turn a blind eye to 18 distinct separate violations of Mississippi Code, and it's not even a close call. It's not even a close call. 15 years I've practiced law, from New York to Texas to Florida to California. I've not seen this type of evidence ever. Clearly documented violations, more than enough for O'Neill. Admissions by every party opponent, by everyone in that room that was working. They admitted they broke the law. Mr. Deering's lawyer, in closing, conceded they had broke the law. It's not the building, gentlemen, ladies. It's the people who are in it. And if we're not going to abide by our laws, if we're not going to enforce them, then I don't believe anybody ever will. I wouldn't care if Senator Sojourner would have won. If she'd have won like this, I'd be fighting on behalf of Senator Deere, and I can promise you that. I'd be fighting on either one of your behalfs if you had lost like this. And it's not Senator Deeren's fault. I agree. Senator Deeren is a good man. I like him. I served with him. He had nothing to do with any of it. But that's not what the law requires. I'll just wrap up real quickly. 64 votes. And just by the testimony we've heard here today, and I haven't even touched the absentee ballots yet, more than double that number is in play. That's the test. Illegal absentee ballots, commingling, fail to secure the ballot boxes, the stain of illegality on Bude. There's only one way to do this, and that's to order a new election. But I know you won't. All right. Begs the question, though, isn't it? These laws we passed this year, which ones do I get to pick and choose? What about the ones I've passed in the last 8 years with my colleagues? Which ones can I pick and choose? We are a nation of laws, the great equalizer. Lady Justice, the idea that no man is above it. But you can rest assured, in a society like ours, it has become apparent to the people that there are two sets of rules. One's for the powerful and the privileged and the rich. Another set for the rest of us. The great equalizer is that no matter who violates the law, we enforce it. We insist on its enforcement. And we have that rare opportunity to do that today. But I digress. It's been an honor to speak to you today. Senator Burton, I mean you no harm. You didn't yell at me much. I appreciate the opportunity. Thank you.
Thank you, Senator McDaniel. Senator Burton, the chairman, I'm going to recognize Senator Burton to close. Senator Burton, you are recognized.
Thank you very much for your indulgence, ladies and gentlemen of the Senate. Just a couple of points. Number one, the sanctity of the process is very, very important. We understand that. But the courts have ruled in many, many cases over and over that the vote of the innocent cannot be ignored. And those who innocently voted, and when the votes were counted, nobody has said none of those votes should count. Just throughout the whole precinct, not individual votes. The vote of the innocent is of paramount importance in this process. The ability to go and cast your vote. And if you need help, you get help to do that based on the law. A strict mandatory interpretation of the law is, of course, the best route to take, the most impressive route, the way we should do things. But there are times when that deviation, because of a misprint, because of a malfeasance on part of someone else, or because somebody didn't put the initial where they thought it should go or where the law says it should go, but the initial was there, all these things should not take away the vote of the innocent. That's what this is all about. I have really enjoyed my service with Senator Sojourner, and the opportunity may present itself again. I enjoyed my service with Senator Deering. When I came into this responsibility, I had no preconceived notions of what the testimony would be other than what I had read after being named chairman in the depositions. I'm telling you, folks, I think the committee has deliberated. I think the committee has taken into consideration everything. There are 3 learned lawyers on that committee, Senator Fillingane, Senator Doty, Senator Frazier, and 2 of us old regular folks, Rita and Terry, and we are bringing to you the recommendation that you seat Senator Deering by passing Senate Resolution number 7, and I thank you for your indulgence. Thank you, Mr. President.
Use of the afternoon roll call has been suggested. Is there objection? Senator McDaniel does object. Therefore, we'll call the roll. If you are for the resolution, I'm going to ask you to vote aye. If you are opposed to the resolution, I will ask you to vote nay. Mr. Clerk, please call the roll.
Barnett. Blackman. Blackwell. Blunt. Branning. Browning. Bryan. Burton. Butler. Carmichael. Kaufman. Chazanol. Clark. Dawkins. DeBar. Doty. Fillingane. Frazier. Galat. Harkins. Hill. Hobson. Horn. Hudson. Jackson of the 15th. Jackson of the 11th. Jackson of the 32nd. Jolly. Jordan. Kirby. Longwitz. Massey. McDaniel. McMahon. Moran. Norwood. Parker. Parks. Polk. Seymour. Simmons of the 12th. Simmons of the 13th. Stone. Tyndall. Tollison. Turner. Watson. Wiggins. Wildman. Witherspoon. Younger. Voting yes or yay: Barnett, Blackman, Blackwell, Blunt, Branning, Browning, Bryan, Burton, Butler, Carmichael, Kaufman, Chazanol, Clark, Dawkins, DeBar, Doty, Fillingane, Frazier, Galat, Harkins, Hobson, Horn, Hudson, Jackson of the 15th, Jackson of the 11th, Jackson of the 32nd, Jolly, Jordan, Kirby, Longwitz, Massey, Moran, Norwood, Parker, Parks, Pope, Seymour, Simmons of the 12th, Simmons of the 13th, Stone, Tyndall, Tollison, Turner, Wiggins, Wildman, Witherspoon, Younger. Voting no or nay: Hill, McDaniel, Watson. Voting present: McMahon.
Three from 51 is
47.
You got one
51.
present.
One president. 46. 51.
47 you
That's
don't
right.
have.
President.
Okay, you don't count the present.
So we got 47.
47.
By a vote of 47 yeas and 3 nays, the resolution is adopted. We are now on announcements. Any announcements need to come before the Senate? Senator Parker, you're recognized for an announcement.
Thank you, Mr. President. The Capital Prayer Group will meet tomorrow. Last week we canceled the inaugural meeting because of the governor's breakfast. We'll meet in room 204. Speaker Philip Gunn will be bringing the devotion, so you're all welcome to attend.
Thank you, Senator Parker. Senator Watson, you're recognized for an announcement.
Adjourn in memory, Mr. President.
You are recognized.
When the Senate adjourns today, I'd like to do so in memory of Dr. Clyde Gunn of Moss Point, longtime doctor there and great pillar of the community.
Thank you, Senator Watson. We'll certainly do that. Senator Butler, you're recognized for an announcement.
Thank you, Mr. President. Adjourn in memory.
You're recognized.
When the Senate adjourns today, we would like to adjourn in memory of Reverend Eddie Wells Sr., who passed on the 14th, and also Mary Louise Patton.
Thank you, Senator Butler. We'll certainly do that. Senator Moran, you're recognized for an announcement.
Thank you, Mr. President. When the Senate adjourns today, I ask that we do so in memory of a good friend of mine, Mr. McCoy Peterson, that passed away this past Saturday.
Thank you, Senator Moran. We will certainly do that. Senator Hill, you're recognized for an announcement.
Adjourn in memory.
You're recognized.
When the Senate adjourns today, I'd like the Senate to adjourn in memory of my neighbor and Joe Sims' father-in-law, Mr. Dale Stockstill, who passed away yesterday.
Thank you, Senator Hill. We'll certainly do that. Senator Chazanal, you're recognized for an announcement.
Thank you, Mr. President. Adjournment in memory. On behalf of Senator Jordan and myself, I ask that when we adjourn today, we do so in memory of Terry Green, a banker from Greenwood who passed away.
Thank you, Senator Chazanal. We'll certainly do that. Seeing no further announcements, I will recognize Senator Burton for a motion.
Thank you, Mr. President. I move the Senate stand adjourned until 10 o'clock tomorrow morning.
You've heard the motion. All those in favor say aye. Any opposed say no. The ayes have it. We are adjourned.